Welcome everybody to Legal Tech Week for April 5th, 2024. This is the show where we talk about the top stories in legal tech and innovation. And I am reverberating back to myself through something here. I have to shut that off. We've got a full house today. Got several guest panelists sitting in with us. So I'm looking forward to the discussion today. So let's kick it off by going around and starting to introduce who's here as panelists this week. Greg Lambert, you want to kick us off?
Sure. I'm Greg Lambert. I'm the Chief Knowledge Services Officer at Jackson Walker, and I blog at Three Geeks and a Law blog and podcast at The Geek and Review.
All right, and Cassandra Coyer.
Hi, I'm Cassandra Coyer. We're together. We just finished. Wait, how do we stop this?
We should have tested this.
Apologies, we always have technology issues when we're together. We had that echo. I should be fine now, hopefully. I'm Cassandra Coyer, and I'm a legal tech news reporter, Isha. I work with Stephanie Wilkins, and we're at IAPP in DC right now. And as you can see, we've had a very long week, so excuse us. But nice to be back. I think I've been here 2 or 3 times now. It's always nice to see some familiar and new faces. So thanks, Bob, for having us.
Yeah, great to have you. And if we can do it without echo, Isha, you want to introduce yourself?
Okay. I'm telling you, it's hard. Okay, anyway, hello. I'm Isha, and I'm the other tech reporter on the Legal Tech News desk with Stephanie Wilkins. And we just finished the IAPP yesterday, but we had like a little meeting this morning, so it does feel like it has gone on for a minute, but it's been great, and yeah, and thank you so much for having me. I've done this a couple times with you, and it's always so much fun. So thanks for inviting me. Yeah,
it's always great to have you. And one of our semi-regulars, but not as regular lately as she has been, Caroline Hill from the UK.
Yes, I'm sorry, it's been a while. Yeah, Caroline Hill, Editor-in-Chief, Legal IT Insider. Joining you from the UK and on a Friday at 8 p.m. Sometimes it's just got other stuff, but it's always so good, and I have missed you, Bob, and everybody else. It's nice to be here.
And turning to our usual suspects, Stephanie, you want to kick it
off? Sure. I am the aforementioned Stephanie Wilkins, Editor-in-Chief of Legal Tech News at ALM, and I'm very happy to be here on this day of the earthquake during Mercury in retrograde during eclipse season. Could not think of a better combination of events, and happy Friday, everybody.
And last but not least, Nikki.
My name is Nikki Black. I'm the head of SME and external education at LawPay in my case, and our other legal brands at AffiniPay. Excuse me. I write legal tech columns for the ABA Journal, Above the Law, and the Daily Record. And I also oversee and author some industry and benchmark reports on the AffiniPay side of things. And I'm going to stop talking now because I'm struggling, obviously.
Good. And I forgot I was going to do this like virtual background. I can't do, Joe's not here, but I did happen to capture him. Joe was on CNN last night talking about the Trump records cases, and captured this little image. So here's a little view of Joe as our background. We can pretend Joe's here, even though he's not able to be with us.
He would absolutely love that screenshot. I can tell you right now.
Yeah, of course he would. Actually, Stephanie got better ones, I think. Stephanie was posting a couple too that she had gotten.
I mean, do we think it's a coincidence that suddenly he's on CNN and he's not here with us on Friday? I think he's just a big friend now.
And he wears a suit to CNN. I mean, does he ever wear a suit here?
No, never.
But did he have a glass of scotch? That's what I'm on. Bourbon?
He was not drinking. Jack and Coke, right?
It's not the same. Just not the same.
Oh no, it's always Jack and Coke.
I brought a wine in his honor. I was like, should I? Well, Joe's not here. I should.
Yes, you should.
Yeah, absolutely. But yeah, no, I did not notice any Jack and Coke on CNN last night. Okay, well, there's a lot to talk about, but I kind of want to kick it off with this non-lawyer thing. There's been this, you've probably seen, a lot of you have probably seen this petition was filed with the ABA this week asking it to essentially ban the use of the term non-lawyer. And the thinking is that non-lawyer is in some ways demeaning, and that it's not descriptive. That people have jobs that are something other than not being a lawyer, and that they should be referred to probably by what they do, not what they're not doing. And it's engendered quite, I don't know if you guys, I know Cassandra and Yisha, you guys have probably been caught up in the conference you've been at all week, but on LinkedIn, it's just been a ton of discussion about it. And it's been funny because some of the people have been saying, like, where did this come from? I never knew this was an issue. Well, like, they've been living in a cave because this has been an issue for a number of years now. I mean, people have been talking
It was a
about this
topic
for
of
a
my
while.
first podcast.
Is that right?
Yes.
Yeah, I thought that was super funny when people are like, how is this suddenly a thing? I've never heard this being a thing. No one's ever said anything. I'm like, well, you can have plenty of arguments against it, but that's not one of them.
Yeah.
You
So,
eliminate
so
I
what do
looked it
people
up.
think? Should we get rid of non-lawyer?
Well, Heather Morris in 2017, I looked it up, wrote an article asking for the legal media to stop using the term non-lawyer in 2017. And I looked it up, and so there were some that were using it just to mean anyone that wasn't a practicing lawyer, whether or not they were a lawyer or not. And the ones like Bloomberg, actually, the only time that they used it in their print media or media was when they were referring to someone that was did not have part of an ownership in a law firm. So there was a very limited version of it, but this has been around since, I don't know, 2000, early 2000s, maybe even before that.
Yeah.
What I thought was interesting about it was people were talking in the some of the LinkedIn posts about the idea that non-lawyer in terms of the regulations is a very specific term. And otherwise, how can you have specificity in the regulations? Well, have they heard of the definition section of a regulation where you state that a lawyer means this and a non-lawyer means this, or legal professional, like lawyer means this, legal professional means everyone who's not a licensed attorney, or whatever, however you want to define it, but you define it at the beginning of the regulation. So what are they talking about? There's no specificity if you don't use the word non-lawyer. You don't hear non-physician, you don't hear non-accountant. I don't know what, that's what sort of surprises me is the level of
I Googled non-physician this morning. Actually, I was curious about this, and it turns out it's used quite commonly. The Harvard Medical School uses it, and others.
non-physician.
Non-physician, yeah,
My
Google it.
husband's a nurse. I've never heard him called non-physician.
Well, I had never heard it
That
either, but I
looks-
Googled it
Yeah.
and I came across
Oh.
a lot of references to it. Surprisingly, I was surprised to see it because the petition specifically says nobody ever says non-doctor, which is, you don't hear non-doctor, but non-physician is used. But anyway, that's beside the point.
But yeah, I was going to say the exact same thing, Nikki, because I mean, people were like making this point of, there are certain ways you have to distinguish, like for ownership reasons, for things like that, who are lawyers, people who are barred, and they act as if without this word non-lawyer, there's no possible way you could make this distinction. And I'm like, it's a word. I mean, a lot of the comments were the same way that anytime anyone wants to stop using any word of just like, we've used it forever. I've never heard anyone say it's a problem. I wouldn't be offended if it was me. How on earth would we use this if we don't use this word? Like, I don't think anyone's saying for all these various reasons you should not make these distinctions, or just saying maybe this isn't the word to use to make these distinctions. And I'm woefully behind on writing up my articles. There was takeaway of the College of Law Practice Management Conference. But the discussion came up there too. Everyone in the room, which is a mix of lawyers and non-lawyers, people from all walks of the profession that work in the practice of law, and everyone just started organically, universally agreed that we should retire the term non-lawyer. And it came up, it wasn't even intentional, but somebody had it was talking about networking, communication, and collaboration. And they put up a picture of an operating room and talking about how all the different people had their different roles and they all worked together. And that wasn't even the point of it about this discussion, but somebody in the following discussion was like, and if you look at that, nobody is looking at that picture and saying, there's the doctor and there's all the non-doctors. And that inspired the conversation of non-lawyers. So it's not new. It's coming up across a lot of gatherings, and people for sure can have differing opinions on it. But so far, a lot of the arguments, like Nikki and I were talking earlier about some of the discourse they have in there, it's just like, they're not thoughtful arguments, which there can be, but these haven't been.
I think at the very best, it's lazy, right? At the worst, it's completely disrespectful, and it's really old-fashioned. I think, like, I haven't seen all of the arguments, but it harks back. It is so old-fashioned. It harks back to a day, when we didn't recognize business services and and all of the other things that contribute to a law firm for the amazing positives and strengths. And actually, and also the way that it's going that's just going to become more so, right? That technology and whatever the roles are going to become hybrid. They're going to become, non-lawyer doesn't even, I don't even know. I haven't used it for a really long time. And like Greg, I remember years and years ago talking or writing about it. And but I think that it doesn't even, what does it even mean anymore? And certainly going forward, it's going to mean nothing, right? I think personally.
Well, if you'll remember a few years ago, the Texas Bar Association tried to ban the term chief because they thought, oh, well, a non-lawyer might be a chief, and we don't want people to think that they own part of the law firm. So, which immediately the entire all of the big law firms were like, yeah, we're not going to follow that. You can just hang that one up.
I mean, I'm just speaking to Shilpa Bandekar from Linklaters today, who's just been made a partner. She's the head of innovation. It's just she's a partner. It doesn't. I think that the definitions have just changed. Yeah, it's just that things have moved on.
The one place I get hung up on with it is with regard to corporate entities, because again, if you look at the model rules, there's a lot of references to non-lawyer ownership of law firms. And I'd actually asked Damian Real, one of the guys who put this petition forward, how they would, what terminology they would use with regard to ownership, like referring to ownership of law firms and who's eligible. And I mean, would you have to, instead of say non-lawyer ownership, would you have to say, ownership by corporations or people who are not licensed as lawyers or something? I mean, the editor in me kind of bristle. I like non-lawyer ownership only because it's concise, but I understand that I understand all the implications of it. I try not to use it in my own writing, but I don't know how if there's a corporate version that can apply. I understand when you're talking about people, you can just use their titles. They're a paralegal. They are a whatever they are. But with regard to referring to the whole ownership issue, I don't know how you do that.
So I'm curious, just because I saw a little bit on LinkedIn of the comments and the debate and back and forth. So how likely is it that we're going to actually see a change with this word? I know you mentioned that it's been talked, this conversation has been around for a while. So I'm curious if you have any thoughts on how likely we're going to see this change or not.
This will be right after the billable hour disappears.
Yeah, I was going to say, I'm a pessimist. Bar associations and their love of change, not so much. But yeah.
We can make the change ourselves, I guess we can sort of choose not to use the term. I've chosen not to use, I'm sure a lot of you have.
Yeah.
But I think it will be an individual or, I'm not sure officially, it will be hard for a long time.
And I also think it just sort of, I mean, we've been talking about this for a long time too, not in terms of that terminology, but it sort of disregards the concept, the whole realization, the reality of what legal practice is now. We've been saying this for a long time. I mean, you need technologists in the practice of law. You need all these people. I mean, so the fact that it's only lawyers and non-lawyers, I mean, there's so many people, there's so many non-legal roles, so many more non-lawyer roles in the practice of law now than there ever used to be even. And it's not the same thing, but like the panel at Relativity Fest that I think it was the one that Bob and Isha, you were both on, where people were like, should we changed the concept of litigation support, that terminology to be more encompassing. I think it's just this whole, there were these old terms that were used for very defined roles, and the profession has changed so much that people do such broader roles, and we have so many more roles that they don't really fit what they were doing before. So even if nothing ultimately changes with the ABA, and like I said, I'm a huge skeptic on that, I think it's just, I mean, people are realizing, at least some people, maybe not the other people in the other chain, the other thread on LinkedIn, people are definitely realizing that there's a lot more nuance than there used to be.
So is it, I guess I have two questions. Is it like, are people offended, or is it more about the specificity issue? And then second, would it be kind of like AP style in reporting where, you know, you stop saying a certain thing and then eventually the cultural inertia just like changes the policy? Is that how it would work for the ABA? I don't really know enough about it, so I was curious.
I think people are offended for sure. Some people,
Some are.
yeah, some. I guess it's like you can't generalize. I guess there are some people who don't care, but I know people who think of it as derogatory. It's being defined as a non something. No, well, I'm actually a really valuable contributor and have a huge role, and by defining me by a negative, it makes no sense. And then in terms of the, I don't know, Stephanie, do you have any thoughts in terms of the second point? Like,
I mean, I do have thought. I think, I mean, not necessarily as, you know, concretely as an AP style thing, but I do think even if the ABA doesn't change it, it will be sort of a lexicon. If nothing else, it might be a lexicon change where if enough people are conscious of it and fewer people start using it, there might be a broader change slowly in the lexicon, even if it's nothing official.
Well, and what I think is interesting, you know, what they're trying to say is that at least for the ethics rules and the other regulations that use the term non-lawyer that the ABA has in place, they want to get that changed. And they, you know, I'm one of the, I don't know what's the terminology, Stephanie? We're both people that were
early advocate, I believe.
Early advocates, yeah. I'm one of the early advocates, but and I agree with this whole movement, but the one thing I sort of take issue with is the analogy that they use in the petition. And this goes back to what you had said, Stephanie, about the likelihood of adoption. I think that the likelihood of this actually happening is also on the lower side, because they talk about how special master was changed to court appointed neutral, but that was changed because of the you know, the historical you know, the fact that master referred to slavery and like that
connotation.
Yeah, that's a different issue than this. This is not, doesn't have that sort of those types of problems. This is more of a issue of disrespect to people who contribute to the work that lawyers do. And so I think that because it doesn't have quite the same ramifications as the special master term, that there is going to be less of an impetus to go and change all the regulations and all the other documents that the ABA has in place that refer to non-lawyer. So I agree. I tend to think it's less likely. And I also think that they're just not analogous. Those are two sort of very different issues. So
I think it's a big leap. Yeah.
Yeah. If you read the petition, what their explanation of it is, they said it implies a binary division between lawyers and others, inadvertently or purposefully marginalizing the invaluable contributions of legal support professionals, paralegals, and other professional colleagues. And moreover, the term non-lawyer fails to capture the rich diversity of roles and expertise present within a legal ecosystem. It goes on. It says more than that, but that's sort of the
we should have read that first. That kind of covers it all, right? Oh yeah, there we go, done.
Yeah. Okay.
Well, and I think there's a broad range of reasons some people might want to keep it as well. I mean, everyone's lawyerly, it depends, right? Because I mean, the same argument conversation we've had about protectionism of the industry in the past. I mean, there's always going to be the segment of, no matter how you apply, or just like, well, we went to law school and we got the degrees, so we are super important, and so we're going to keep it. That's certainly not all the reasons people are arguing against it, but for some people, sure.
Well, but you know what I was thinking about? I was thinking along about that general concept, Stephanie. I think it's not only that lawyers went to law school and got a degree. I think it's that until lawyers went to law school and got a degree, most of us felt like we weren't good enough. We weren't good at STEM. We didn't get the, you know, the recognition we deserved. You know, everyone acted like our majors were fluff majors. And so we finally like made it and got this degree that made us special. And God damn it, we're going to be lawyers and no one else, you know, everyone else is a non. I feel like it has to do with that too. It's like the
Oh,
psychology.
right. Because we were like the smart
we
kids
are.
who didn't like blood or math. So we had to do something and get our degree. Yeah.
Yeah. All right. Well, all right.
Well, if you were looking to
we'll-
fire up the crowd there, Bob, you did a good job.
Yeah, that was a good starting point, right? Like Nikki
and we
said,
haven't, and we haven't even gotten to lawyers being disciplined for misusing Microsoft Word yet. But before we do that, we have let's turn to our guests and maybe start with Cassandra and Isha, who have, as we now know, are together in DC at a conference. And if you've been reading their reports this week, you would know that as well. But at the privacy conference, I forget the formal name of the conference, but you can tell us what's been going on there. What have you been hearing? What's interesting? Who wants to go first without
Okay.
drowning out the other?
Okay. So it's the IAPP's Global Privacy Summit. And it's a pretty huge conference. And it's a little bit different than the ones that we're, used to going. There, it's less legal tech and much more, obviously, just focused on data privacy. It's been interesting. It's only 2 days, but it feels like, like most conferences, it feels like 10. And there was amazing panelists, amazing keynote speakers from federal agencies, attorney general's offices across the states to talk about sort of enforcement actions, past and future, and just more, also very sort of high level trends in the data privacy space. So facial recognition, voice clones, biometric data, children data, health data, the list goes on and on. But it was a really interesting one. Obviously, as you can imagine, AI was everywhere. And I think a lot of the legal professionals here, as we call them, not lawyers and others, a lot of the legal professionals here were sort of a bit frustrated, I guess, at the focus on AI. But it seems to have sort of, they were saying this is the biggest, conference they've had so far, which I feel like we hear at every conference that we go to. It just keeps growing and growing. And in this age of AI, everything is a little bit more relatable, I think. But a lot of big takeaways and really interesting insights. And it's interesting to sort of move away from what we constantly cover. This is the regulation and this is the lawsuit, and sort of take a step back and hear, okay, what are the things that people are actually worried about? And sort of one random anecdote that I can throw out to sort of show, that the different approach that they take to this. One of the keynote panelists is this founder, I believe from Italy, Rochelle, and she founded a clothing line of garments that are meant to sort of trump the AI and confuse AI so that it can't use facial recognition on you when you're wearing those clothes. So she was on stage and she showed sort of what the clothes look like. And it's a little bit more complex than just wearing a t-shirt with, a picture of a dog on it. That doesn't work. That doesn't confuse the AI. I can still figure out where you are. But it's sort of the specific patterns that somehow confuse the facial recognition software. So it's really interesting to just see, outside of the little box that we tend to be in, what others are worried about and what they're doing. So I think that was a really sort of standout moment, at least for me. But I'll let Isha jump in, also from DC, yes, also a non-lawyer. I'm kidding.
I don't like to be referred to as a non-lawyer.
You're otherwise professionally enabled.
Yeah, that's it rolls right off the tongue. Yeah, everything Cassandra said is super interesting. I'm like honestly still processing there's so much information, but it was interesting to hear, we always do hear like at Legal Week, also we hear that, it's the biggest so far. And there were more, I believe there were more folks sitting for the privacy certification test this time than ever before. So it is really top of mind at companies.
They have certifications, I believe. People are getting certified as AI experts, whatever that means. So that's also an interesting thing that was happening this year.
Yeah, they AI privacy certifications, whatever that means. And a lot of regulators talking about, like I feel like we've on the defense and the vendor side, we always hear like frustration with the regulators, or from privacy advocates, sometimes we hear, oh, the regulators aren't doing enough. But here there was like the FTC and local state regulators, and they were basically saying like, none of this should be shocking to you. You know, we've been talking about geolocation data. We've been talking about consumer different ways to kind of confuse a consumer and what that would look like, and none of this should be shocking. So, you know, I believe today's takeaways for me was kind of looking at what litigation trends the regulators were mentioning were coming. And some of the interesting ones were, of course, we're talking about connected cars a lot. We heard a lot about connected cars, which are basically cars which have Wi-Fi embedded in them. And, you know, they were saying like projected by 2030, over 90% of all passenger cars are going to be connected cars, and what that means for our data. And recently there was the LexisNexis, General Motors situation in New York with data sharing that, you know, consumers weren't aware of, that jacked up people's insurance premiums. So a lot of things like that, a lot of conversations about algorithmic disgorgement, which we heard more recently in the New York Times lawsuit against OpenAI as, you know, demanded damages. And yeah, what else would you say? What else were they? Here, let me do the thing.
Kashmir Hill was there, right? Speaking.
Wait.
Oh,
Wait. Okay.
Kashmir was incredible. Did it work? Okay. Kashmir was incredible. And you know what's funny is the audience really resonated with her, and she was sort of making jokes on stage because she was like, hey, I'm coming after all of you. I will investigate your company and I will find out this is how I did it. I will do it again. And yet, like, the audience really seemed to resonate with her. Everyone wanted to get their book signed by her, which is sort of funny because I know every time we enter a room, everyone is always like, off the record. And yet they were all rushing to, you know, make buddies with this journalist. So it's kind of an interesting thing to see. But in terms of also really interesting panelists or keynote speakers, Anu Bradford, she's a Columbia law professor and an author, and the author of this book about digital empires, which I would really recommend everyone to look into. Maybe not read it all if you can't, but really look into this idea of sort of the US, EU, and China has these like 3 different digital empires, and what this means in the age of AI and how they're approaching technology governance, and sort of which model is going to win, which is unclear, but there's a lot of moving parts, and I think that are going to get amplified during this Gen AI era that we're in. So a lot of food for thought. Yeah, and one more thing I will add, which I think is also interesting, because I know the legal tech industry has been talking a lot about deepfakes and what this means. I think this was the first time, at least for me, and again, I'm not a privacy professional, but it was the first time that I heard regulators locally here in the US sort of talk about the fact that, you know, you always see in those state data privacy laws, the reference to vulnerable groups, which usually means children. And they were sort of saying this week, you know, vulnerable groups, we also mean people that don't understand the technology quite well. And that is going to be sort of a big priority for all these regulators and enforcers of those laws going forward, because deepfakes are even more confusing. So even if you understood the technology up until now, you might be sort of, you know, get back and starting from the ground up. So yeah, I think a lot of interesting things coming. Isha, go ahead.
Not even. Okay, sorry. No, no, to jump on that, I'm curious. I don't know if this term is like, is it offensive or inappropriate? I'm going to say the term, but we were talking about it. We were talking about it because I'm doing a story on India, the EU and the US, and how the different jurisdictions are regulating AI directly in response to the election this year. And in India, like, all the lawyers were using the term called tech illiterate. And I don't know if it just sounds like, and I'd never heard that before, but Cassandra and I were talking about this focus on what a reasonable consumer is and how the FTC or other regulators are looking at that. And I guess the alternative is someone who's tech illiterate. And I don't know, have
Did
you
you
guys
see
heard this?
Roberta's comment in the chat earlier when we were talking about non-lawyer, that saying that maybe we should have lawyers refer to themselves as non-technical,
Oh, so those,
or
it's
maybe
the
just
lawyers.
non-competent.
Okay, asked and answered. The FTC is focusing solely on lawyers when it comes to not understanding their privacy policies, which seems to be true.
Well,
but yeah,
the people on LinkedIn who are pro non-lawyer did not like the term legal innovator at all. So I don't know.
oh, interesting.
Interesting, yeah.
Oh, huh. They don't like any lawyer? Oh, well.
Okay, so non-tech literate. Okay, so Greg, you think the illiterate part is the
The problem.
yeah, is the problem.
So is it like the opposite of tech savvy is tech illiterate? There's no in between?
No, but I think I don't know, because I heard it more. That term was mostly used by Indian lawyers. But in India, like illiteracy is, of course, like maybe you're literally talking about illiteracy, but no, but he was saying it's tech illiteracy. But we were trying to equate that with, if it's not children, and if and then if it's a reasonable consumer who, I don't know.
I don't know how they're gonna.
I don't know what that term, but there was a big focus on that idea of not being buried, things being buried, dark patterns, not understanding a privacy policy, as we saw, of course, with the Microsoft abuse retention issue as well that we were covering a couple weeks ago. Yeah, there was a big focus on that from regulators, is what I'll say.
Well,
Anyone see
Yeah.
Mark's comment in the chat? Upcoming conference tags non-lawyer, like we're gonna, like,
Love that. I love that.
that's actually a good one. I like that. We have so many good T-shirt ideas that have come out of this show. Well, how about since we're talking about deep fakes, Greg, what, Tennessee wants us all to wear Elvis T-shirts or something? Is that?
Yeah. Well, as most politicians do, they bend themselves into a pretzel to make a law say, come up with some term that fits the narrative. So they've come out with the Ensuring Likeness, Voice, and Image Security, or Elvis Act, which goes into effect, the sign goes into effect July 1st. And Isha, I didn't know you were going to be here because now I feel like a non-tech reporter to write on this, or non-lawyer or non-reporter to talk about this. But it's really interesting because you're hearing a lot about things like OpenAI just came out with, well, a few weeks ago with their video, Sora, which takes text to video. One of the things that was also announced but didn't get nearly as much hype is their voice programming now you can take 15 seconds of someone's voice and it will clone that voice. And I think when people think of cloning the voice, they think that it's my voice, but it's read, it reads things perfectly like the AI that I use for my automated podcast does, but that's not what this does. It actually, if you give it enough of your voice, it understands when you say and ahs and oh, and it knows you're pausing. It knows the whole inflections, or it learns that. So it's a little scary when you start playing with this. And so a lot of states are jumping on in it, and it's really interesting because when I think I know everything, I suddenly realize there's something I should have known for a long time that I didn't know. And that's like NIL for college students, which I didn't know what it stood for the longest time until recently, which was name, image, and likeness. So if you didn't know that, please let me know so I don't feel as bad. But and it looks like a lot of these laws are kind of following the same kind of pattern where they're looking at name, image, likeness, and voice. And so the regulations are being set up in this type of format. What's really interesting and so American is, of course, now there's companies that are coming in, in Nashville, there's a company called Vinyl, VINIL, instead of YL, that is actually licensing, is setting up a licensing of name, image, likeness, and voice for artists so that they can have it, and then they will go out and protect their name, image, likeness, and voice, just like you have for other copyrighted issues. So, and you can and not only that, but they'll set it up so you can license it. So if someone wants to make a song that sounds like me, I can go out and license that and make money off of my voice, even though it may be AI. So I think you're going to see, as the states are really, the federal government, U.S. federal government is so bogged down right now that I don't see a lot coming out on the federal level, but I think on the state level, you're going to see much more of these, and especially in states like California, Tennessee, New York, where there's a big push or a big contingent of artists that are there, then you're going to see a lot more of these regulations and laws coming out.
Yep. Targeting deep.
I didn't know NIL, Greg. And
Thank you.
It's funny how they've used nil to represent something. So right, like, so this is you, it's nil.
Well, it came out of the college sports stuff, right? Which doesn't really translate to the UK as much because you don't have the huge college sports industry where college athletes couldn't be compensated. They weren't allowed to get compensation for anything. And then now there was the whole lawsuit that now they can be compensated for their name, image, and likeness. But the whole, like you were saying, Greg, they can learn not just your voice, but your cadence and your ums and your ahs. It's exactly this, like the story I wrote back in January about Lori Cohen, which was the good, feel-good story. That's exactly why it was such a great use for her. And like since then, 11 Labs has been helping other attorneys. And I mean, I get it that that's a unique situation where it's being used for good, but it's like, it's so tricky because there's such potential for horrible use of this. So to like quash it entirely and take it away from somebody like Lori isn't the answer either. It's just so, it's like with everything where, I mean, the capabilities of this are so incredible. And for certain people, it is so life-changing in a good way, but then people are going to do such terrible things with it that I just like, don't even know what to do sometimes.
I don't think they should. I think this is an example of where, the regulation is not there. Like we can see the potential for bad is just huge. The potential, when I was speaking towards the end of last year, asking CIOs to reflect on some of the big advances, one of them was saying, we really have to, that voice is going to be the next frontier that we've, in terms of cybersecurity. And obviously they're trying to train people because we're so used to assuming that if you hear someone's voice, that it's them, and we haven't got there yet. And I just feel like, the cart is leading the horse, in my opinion. There will be uses for good, right? But until we can at least try and get ahead of this, then it should be the case. Somebody should have the power to go, no, we're not going to use that yet, but there's nothing.
Yeah, well, and the government got so they did almost absolutely nothing when it came to social media to try and curtail that you're going to have that pendulum swing so far the other way that they're going to try and jump ahead of all of the AI and cloning. And so it's going to get so much worse before it gets better.
Yeah, I can't, I feel like we've been talking about this at IAPP a lot, is, this idea of how much do you curtail it before you're just kind of left behind. And I just think, like, I can't imagine a situation where it's just like already there. Like, I just can't imagine a situation where, it's not going to be used. And yeah, like Lori's such a good example of something so incredible. But I wonder, I feel like it all just comes down to consent, and which comes down to consumer education. And I feel like that's the only part that we can probably work on at this stage, and force companies to make clear what exactly they're doing with the data. Like, I don't think that, I just can't imagine a situation where the technology itself is not going to, like, we already have Sora. They're doing things faster than like, I don't know that the government, like, they still mess up their emails and things. Like, I just can't imagine. I don't know, maybe I'm being too like blasé about that, but
But I also think it's how easily you put this in people's hands to use it. Because like on the one hand, like Lori Cohen, like she was using 11 Labs and she had to like jump through hoops. They had to do
Right.
all of this work to figure out how to use it for her to do it in court, and now they're doing all this stuff. But then it turns out like a company actually figured out that, you know, the Biden robocalls in New Hampshire, they were able to trace those back to 11 Labs because they actually made a product that was like, hey, anyone, just for funsies, you can do something in Joe Biden's voice. Like, maybe don't make that an available product. Because like the foreseeability of somebody doing something like that with that is fairly obvious because we know the nature of humanity. Or maybe that's where I'm just a super pessimist here. Just a realist, I say. But like, I mean, I think something like that is like you're putting it in the hands of people on a silver platter, being like, here, go ahead, do people with the fake president.
They're going to be able to. They're going to be able to do that anyway, whether without, you know, they're just going to be able to. You can just do what you like with people's voices, and I take your point about, you know, are we too far? Is the toothpaste too far out of the tube? I do feel like that. You know, one of my points was the AI, the US UK safety agreement that they came out with. And again, you know, I was going to ask you guys whether you thought that had any teeth, but if we get to it, but you know, I do think that the point that Cassandra made about the t-shirt that defeats the, you know, facial recognition, I think that basically there's going to be to a certain extent just a race of like, can we create technology that detects, and in that case it would be, can you create technology that detects whether this is, if that's even possible, whether this is real, whether this is fake or you know, I think there's just going to be to a certain extent a continual race to just technology to get ahead of other technology to try and detect, you know, can we detect whether this is created by ChatGPT? Can we create something that will, you know, that will deceive AI? I think that to a certain extent that's where we're at.
Like the tool I sent around to you all that was like Nightshade, the one that poisons AI image generators by putting cat faces on everything.
So
That was great.
Was that
So
great?
Caroline, we're cutting into your Friday night here, so we got to give you a chance at least to talk. And I know you had a couple of stories you wanted to talk about.
Well,
Which one where do you want to start with your?
Yeah, well, no, that one, well, that one's quite relevant, and I don't know if you saw it because one of the reasons for bringing
I
it
didn't
up.
actually see it.
I mean, to be fair, my site so my techie is working on my site, and right now, if you try and click on my story, it just says can't access. So maybe let's not go to my one, which is really unhelpful. But so it was
I got it.
have you got it?
Signed by, yeah.
Oh, have you opened it? Oh, I tried to open it whilst we were talking earlier, and it just said, let me see if I can open it now. It was that great timing thing, and I still can't open it. Okay. Maybe you should talk about it, but it was the bilateral agreement between the US. I still can't say it, but anyway, I'm just going to talk. So it was the US and UK first bilateral agreement between two countries, talking about collaborating when it comes to testing AI. So I was curious as to whether you lot had seen it and what you thought about it in terms of, obviously this is very high level. How does this translate to sort of the businesses on the ground? The reality probably is not yet, although interestingly, they have said specifically that they will be collaborating on testing. It might be OpenAI, it might be Google, and testing. They call it the safety, you know, testing the safety of these models. It's really important that they're collaborating. They're actually investing. They are exchanging information, and I mean, it's interesting that this conversation comes after some of the things that we've observed about to what extent will this make any difference in practice on the ground to people who are practicing and who are in business, who are already facing some of the real world challenges around cybersecurity, et cetera, et cetera. I think it's a really positive step. It's a first, so I thought I'd bring it up. It follows the European Act, which is quite different. So they're taking a very much sort of, you know, they're sort of a much sort of harsher regulatory stance. But here it's a case of knowledge sharing, collaboration, which I think can only be a good thing. But in terms of practically on the ground, I'm not really sure that anyone's going to feel the benefit of it, to be perfectly honest with you. I don't know if anybody else saw it.
I had noticed that earlier in the week, and being firmly grounded in the Star Trek universe, I think this is a good idea, because the only way we're going to be able to defeat the aliens and the AI when there's an uprising is when we have like a worldwide, you know, collaboration. And all joking aside, though, I think that's the only way that we really can effectively, aliens aside, you know, address AI and ensure that everyone's on the same page, and that we're able to, as this technology rapidly develops,
Yeah.
regulate it across the board and not use it as a weapon against another nation state or for, I think that's the direction we need to go. And I think it's nice to see something sort of headed in that direction.
And it's interesting because it brought out a lot of conversations about open source and closed AI, right? So, and at this level, they'll be able to presumably, to a certain extent, encourage, foster, invest all of the things in open source technology and so actually it will become potentially damaging to refuse to sort of open up the box, as it were, to kind of share information. I would imagine that it will be, encourage companies to become much more, hopefully, transparent, which is what we need. Bear in mind, we don't even still understand what goes into some of the more closed AI technology that we're already using.
I tend to be cynical about these kinds of things only because, I mean, so, if you have the US and UK collaborate, well, there's a whole bunch of big players out there in the world who are not part of that equation.
So they've said this is the first. So they said specifically that this is the first. So we obviously there was a lot of emphasis on our special relationship, which obviously we have, we and the UK being completely frank, we're like, yay, they still think we're important. Even though we're not in the EU.
But then there's also like the whole sort of like crypto element to it. I mean, where part of it is just unregulatable, not regulatable. Yeah, I guess that's a word. I don't know. But I mean, so much of AI development is just sort of beyond government regulation. I mean, it's just going to take the course it takes, and it almost ends up not mattering, in some ways, what government limits are attempted to be imposed on it. I don't know.
Apart from, I think that I think they can, well, I don't know. I mean, there will be potentially it could lead to regulation, right? I guess. And I take your point. I think that we have been so far behind in terms of regulation. I think it's now all, case of what do we even understand what it is, right? I suppose that's the first. Do we understand? And we've got to have understanding in order to even move forward. And then they can start thinking about some kind of regulation, a bit late, but and I do think that it will be a case of that in high level investment, and there'll be all sorts of ways to incentivize dealing with. I think it's important, but yeah, I do think it's a bit, in terms of controlling it, it's already out there. We're already using it. Also, a lot of the damaging stuff is already out there. So yeah, be interesting to see where it goes. Yeah, it's interesting. Dennis, that's a really interesting point. Dennis says, we've all agreed to terms that were transparently disclosed to us in click-through agreements we didn't read. Yeah.
Yeah. All right. Nikki, do you want to talk about we've got a couple of stories. We could either talk about a high-level view of the state of the legal profession, or about how a lawyer screwed up using Microsoft Word and got in trouble in court.
I feel like I just threw a whole bunch of things up there in case we didn't have enough panelists, and clearly we've got enough panelists. So I think that the Word one is the most interesting. It's an ABA journal article where the judge, I think, correct me if I'm wrong, I'm not trying to remember the exact sanctions, the lawyers tried to avoid sanctions and the judge sanctioned them because they submitted a brief that included footnotes, and with the footnotes, it went over the set word limit. And the lawyers said, listen, it was just there was someone inadvertently checked a box that excluded footnotes from the total word count of the document. And the judge said, I find it hard to believe that a sophisticated law firm like yours would have that issue. To which I sort of responded, has she ever used Word? Like, I suppose the last time this judge dove into Word. I mean, Word is the most convoluted tool. And I never use it because I can't figure anything out. Nothing's where you think it is. So I used to use Pages, and now I use Google Docs because they're so much more user-friendly. Word has a ton of capabilities, a ton of depth, but with that depth comes ridiculous, embedded menus with all these other things. And if you do miss, one box isn't checked right, or you accidentally check a box, all hell breaks loose. Like, I feel bad for these lawyers, and I feel like this is another example of a judge who is not tech savvy Not understanding exactly what's happening, but I thought it was interesting. I don't know if someone put that in there or not.
I
go
put,
for
yeah, I
it.
just
Oh,
put it
there
in
you
there.
go.
Yeah,
Okay.
yeah.
I thought it was interesting and it made me laugh because I feel like the judge is, sitting on a high throne up there and has no idea what's happening in the real world.
Yeah, I wasn't sure whether to side with the judge or the lawyer in this one. I mean, it did seem to me in oversight on the lawyer's part, again, especially given this is, a sophisticated lawyer at a high-priced firm, where you would think somebody at some point might have said, "Did you check how you're setting your settings in Word to figure out how you're calculating total words in a document?" Um, it did seem a little bit like to me like the lawyer's the lawyer's fault, although the judge may have overreacted a little bit, I guess. But
I think it harkens back to what we talked about last week, though, and that I'd written about in my article, how ChatGPT and generative AI is shining a light on lawyers' incompetence that's always been there, but you were never able to prove it. And so they always got the benefit of the doubt. The way that you just described that someone at the law firm or should have told the lawyer to double check, or the lawyer should have known to double check. I mean, the other thing I want to mention is you're assuming that lawyers have in-depth knowledge of Word. And, remember years ago, I think it might have been Casey Flaherty created a
yeah,
test to see if you're tech savvy or not, or have
yeah,
tech competence.
that still exists. Yeah.
I always thought that test, though, didn't test the right things, because lawyers shouldn't have to know the ins and outs of an Excel spreadsheet or Word for that matter, right? I feel like tech competence in the legal space, or maybe they should need to know Word. This case might be an example of that. But I always felt like it was more understanding technology, understanding how to vet providers, not the intricacies of these programs that typically non-lawyers use. So legal professionals use. But, I can't tell if this case highlights the validity of his test or sort of supported my perspective, which was always like, I feel like that's testing some of the wrong things there. But I think it's interesting. But does anyone else think that lawyers should know the intricacies of Word to that level?
Well, his thing was some of it was just like removing metadata and that kind of stuff. And yeah, you ought to know how to do basic stuff like that, I think.
What I meant for
How
Word.
to redact a document, how to remove metadata from a document. I mean, those are sort of
It's
fundamental.
so complex. There's whole businesses that have sprung up around helping people to unscrew up Word, right? Like, like that kind of 3 a.m. Oh my God, I've tried to make
Yeah.
a whatever presentation or whatever it might be document, and I've literally screwed the whole thing up, and I don't know how to unscrew it. I don't know. I think a certain amount of training, but yeah, it's difficult to know where that stops, right? Like where in terms of time, where you should be spending your time and where you should be trained, and yes, being able to use a basic level of Word, but I'm not sure how in depth that should go beyond. Then presumably you pass that on to somebody else. I don't know, or maybe that's inefficient.
This is
Yeah, I
why
mean,
all the
there are
boomer
enough,
lawyers in the room keep saying, "Whatever happened to Word Perfect?"
there are enough weird random court rules out there about font sizes and margin sizes and whatever. Like, somebody should be looking over all of these things. So I do agree that it was, they messed up, but for the lawyer to be like, or for the judge to be like, how could anyone possibly mess up Word, was a little bit. I was with you, Nikki, where we were like, has he used Word? Like, do we know how horrible it is? And like, yeah.
Yeah. Well, all right. All right. Well, one other. I was going to talk quickly about a story I did this week. Just 'cause I thought it was it's another cool thing toward open access. I mean, I've been writing a lot lately. I have a couple of stories. Things have come up in terms of providing open access to legal information. And this week, Yale Law School launched this new thing called the Law Archive. And it is basically devoted to free and open access publication of legal scholarship, law review articles, and that sort of thing. Kind of a focus on, I guess, what they call preprints, which are the articles that are written but not peer reviewed at that point necessarily or published anywhere formally yet. But this is meant to be an archive for publishing legal scholarship of any kind, and I think it's kind of a reaction to SSRN and what's the other one? I can't remember what the other. Greg, you would know what the other one is called, but there's another repository for these
The
things that are paid
archive?
Well, there's another one, B Press or something, B Press maybe, that publishes a lot of this stuff. There was formerly a free and open archive of legal scholarship materials that died in 2021 because it basically didn't have any money and the tech was all screwed up. This new archive is actually running on the same platform as the old one, except it's a new and improved platform. But this time it has the backing of Yale Law School and several other law schools, so it has financial support and it's therefore likely to continue on into the future. So um, a notable, I think, move from Yale and kind of a shot in the face to some of the private publishers out there that are charging for access to the scholarly information.
Yeah, I mean, that kind of runs in, I think, in a 15, 20-year cycle. Because I remember that as soon as the internet hit in 1994, right, roughly, the first thing that you heard on college campuses is, "Oh, great! Now we don't have to pay." And literally, I worked at OU, the main library. Some of those math journals were $100,000 a year
Yeah.
to have access to. It was insane, and that's 90s money.
Yeah. Yeah. All right. Anything else anybody want to bring up before we wrap it up for the week? Well, thanks a whole lot to our guest panelists this week. I appreciate all of your contributions and insights, and good to see you. And thanks to our regular panelists, and thanks to everybody in the audience for spending Friday afternoon or whatever time Friday it is for you, evening, morning, with us. I appreciate it. And we'll see you all next week. Have a great week.
Thanks, everyone.
Bye.
Have great weekends.